All right, everyone, if you can take your seats, we're going to start again. Okay, so we're going to start the next section, and it's also somewhat a different topic than what we have been discussing before. But it's something that we have talked about in our Environment Committee, and that also links somewhat to the topic of the previous panel. So this is about climate litigation and reputational damage. Well, this is me again. And this time it's going to be moderated by my colleague Bradley Forder, who is Head of Communications at worldsteel. So I'll leave it to you.
Thank you very much, Åsa. Good morning to everyone. As also mentioned, my name is Bradley Forder. I'm Head of Communications here at worldsteel, and I'm happy this morning to be talking about this increasingly important topic of climate litigation and its effect on the reputation of the steel industry. Now, why do I say that it's an increasingly important topic? I think, as we all know, and perhaps especially as we've seen just in the previous panel there, as the steel industry is more transparent about its carbon emissions and other sustainability credentials, as customers, civil society organizations and others are more open to questioning or challenging those claims, some of which have legal consequences, all of which can take place in the public eye, all of which detrimental perhaps to the reputation of the steel industry as a whole, at a time where we know at worldsteel that the reputation of the steel industry is actually declining. Now, how is it that we know that? For those of you who were perhaps here at the Open Forum last year, I did a presentation on a piece of reputation research that we do at intervals of every 4 to 5 years at worldsteel through the Communications Committee there. We do it in the top 10 steel producing countries around the world. We interview customers, suppliers, governments and others, quite an informed high-level audience who tell us their opinion about the steel industry's performance in many areas, not only sustainability and climate change, but also safety and others. I won't go into many of the details of that. Indeed, as all the other presentations from the previous year's Open Forum are, it's available on the website. But for now, I'll just give a very brief overview before I hand over to the speakers on this panel about what we saw from the results of that research. First of all, there's a correlation between the familiarity that people feel they have with the steel industry and how favorable they feel about it. It's a correlation that in previous iterations was much stronger. In the most recent one, it's the case that is breaking down. So the more familiar people feel about the steel industry, increasingly they tell us they're more critical of it. There are differences in some of the countries that we can see there. India enjoying a very prominent position in the top right-hand corner there. Germany less so. And if we compare some of the 2002 results with the results of the previous iteration in 2018, we can see that actually, with the exception of India, basically, the reputation of steel, for many different reasons, has declined in all of the top 10 steel-producing countries or regions. In some cases, the USA being one, Germany being another, and Brazil probably being the last one, quite precipitously, quite modestly in other places like South Korea and Turkey, but nevertheless of concern to the communicators and everybody in the industry. Now, when we ask people why they might feel negatively about the steel industry, overwhelmingly it is because of its, or rather their knowledge of its contribution to climate change. That's perhaps not surprising. What might be surprising for us is the extent to which steel doesn't really perform that well in comparison with some of its competitor materials or other materials? These are some questions that we ask people about steel and the other materials listed at the top there. That steel is strong and durable is perhaps not so much of a surprise. You'll see that when we ask people to what extent steel is producing climate change, it comes just in second compared to plastics. Some takeaway there is perhaps if you compare it to the concrete industry, which is also responsible for between 7, 8, 9% of global carbon emissions, steel is performing much worse. And then conversely, when we come to the more positive attributes of steel, the ease of recycling it, for instance, we are performing not perhaps as well as one might expect. Only 57% of the respondents to the survey considering that it's easy to recycle. So it's in this context of a declining reputation that we have asked the following three speakers to talk to us about developments in climate change litigation that are playing out in the public eye in recent months and years. All three of them are lawyers. We'll be first joined by Kenneth Markovitz, who's a lawyer for a legal firm called Aiken, based in Washington, D.C. He co-leads the firm's climate change group there and advises his clients on setting sustainability targets, among other things. He'll be talking to us about the basics, the trends, and the numbers of this topic. After that, we'll hand over to Parul Kumar, who's Deputy Executive Director and the Climate Director of a think tank based in Berlin. And then finally, we'll hear a presentation from Ana Ruiz, who's a policy analyst at ERCST, the European Roundtable on Climate Change and Sustainable Transition, based here in Brussels. And then after that, we'll have a discussion involving all three of them, taking questions from the floor. So on that note, I can hand over to Kenneth, who's very kindly joining us from Washington, D.C. at an outrageously early time for him. We have in the room his slides up. If we could get the camera feed of Kenneth. Hi there, Kenneth. Can you hear us here in Brussels?
I sure can, everybody. Good morning.
Splendid, and we can hear you perfectly here. So I will hand over to you, Kenneth. Just let us know when you want the slides to proceed, and we'll manage that from our end. So I'll leave it to you to introduce yourself and to go through your slides. Thank you.
Thank you very much, Bradley, and good morning again, everyone. Asa, thank you very much for inviting me and co-panelists and participants for sharing this presentation. Really appreciate the opportunity to discuss with you climate litigation. We're going to start today talking about just some of the basics behind what is climate litigation, the different types of climate litigation, present a few numbers on how it has been percolating around in the United States as well as other parts of the world right now. And then we've worked to bucket climate litigation into a number of trends that we've observed. We'll start with talking about the one that's been really on most people's minds these days, these deception campaigns or greenwashing. And we're going to go into damages and accountability for products and operations, some of the historical legacy cases that have led to climate-related damage around the world. Another growing trend is enforcement of inaccurate, inadequate, or untimely climate disclosures. The directive in Europe, we have a new rule here in the United States from our Securities and Exchange Commission, and more around the world, mandatory climate disclosures are being required by governments well beyond activities from CDP and other voluntary efforts that had been at the heart of climate measurement and reporting. And we're going to discuss some of the recent activity around carbon markets and carbon projects and their use in carbon neutral claims and companies' net zero targets and activities. And finally, just some nuts and bolts on government enforcement of regulations. So we'll work through these, and then I look forward to hearing your discussion, your questions, and I'm really sorry I'm unable to join you in person, and please bear with me. We are at the crack of dawn here. The sun's not quite yet up in the East Coast of the United States. So thank you. And if you could, Bradley, please turn to the next slide. Thanks. So climate litigation, what is it? It broadly refers to legal actions seeking to redress damages from climate change. And this can take many different forms, and the damages can take many different forms. It's being currently used as a tool primarily to hold governments and corporations accountable for the contributions they have been making to climate change and its impact. Wide variety of plaintiffs, of stakeholders that are bringing these actions against corporations, against governments. You'll see that primarily these actions have focused on the oil and gas industries, but we're starting to see trends that it's moving out into other sectors in many different areas of this. And the extractive industries, the heavy industrials are prime for this next round of climate litigation. And it's all the more important that the steel industry pay attention to these trends and these lessons being learned in these other contexts from the oil and gas. We're seeing suits being brought by shareholders to hold their corporate boards accountable, by public interest groups such as environmental organizations. You may have heard of Client Earth has been working around the globe tirelessly at bringing testing different legal theories against companies and governments to hold them accountable for the impacts of their climate actions. We've seen property owners who have found damage. There's communities who are bringing suit for environmental and climate justice reasons. And then there's also governments who bring enforcement actions against their companies in their jurisdictions, as well as seeking to change behavior of companies in their jurisdictions. It's really been a trend started about 7-8 years ago and continues to grow. Just for context, outside the United States, we've seen over 90% of the cases have been brought by non-governmental organizations or individuals. And while there's a reduction in global cases that have been filed against governments, which historically made up about 70% of the cases, in the last 12 months, this is 2023 data, only around 54% of the cases were targeting governments. So we're seeing this trend of shift towards strategic litigation against companies and new theories of law being tested against corporate actors and again, a growing range of sectors. What are they being used? What are these legal actions being used to do? First and foremost, I understand maybe you've touched on this already. They're challenging the veracity or the truthfulness of climate commitments. So you company make a carbon neutral pledge or claiming products are carbon neutral. We're going to be net zero by a certain point in time. Where's the data to back that up? What are the scenario analysis that you have undertaken to assure that you're going to meet those claims or those targets? Do you have an emissions mitigation plan? How have you addressed scope 3 emissions, those from upstream and downstream in your supply chain? These all go to the veracity of climate commitments and are at the heart of a growing greenwashing type disputes. We also see increasing scrutiny on enforcement of regulations, enforcement for failure to deal with the disclosure requirements fully, comprehensively, accurately, non-compliance with environmental permitting or greenhouse gas emission limitations. We're also seeing a whole bunch of cases, and this is often at the heart of some of these environmental groups thing, is to spur climate action. Like to have governments deny permits for carbon intensive activities or to take actions on developing adaptation or resilience strategies. We've also seen in this instance and in this bucket actions to prevent the flow of money to high emitting or harmful projects or activities. And we're seeing cases being filed around that. And then finally, seeking damages for climate impacts on human health and the environment, as well as the economic interests of shareholders. For example, damage to human health and the environment includes, physical damage from catastrophic weather events such as hurricanes. And these decisions play a very powerful role in shaping how the law and regulation will evolve over time as well. So we're seeing that these high emitting activities initially in the oil and gas sector, though, are now really challenging companies at different points around the life cycle in their product development process, and from initial project financing through final project approval. Next slide, please. So the majority of these cases have been filed in the global north. By looking at the Sabin Center, which is at Columbia University in New York, they have a wonderful climate law center where they have a climate litigation database, and they have identified over 2,300 cases that have been brought worldwide. However, right now, there's only been about 135 or so cases recently brought in the global south. This may be a trend that we're seeing a shift, however, and testing new theories in different jurisdictions. We saw last year only about 190 cases filed in the last 12 months. And while the growth rate of cases appears to be slowing, the diversity in the type of cases and the legal theories that are being tested continue to increase. Most of these new cases, as I mentioned before, are now being brought against companies that extract or supply fossil fuel, and these do continue to proliferate. However, new and ongoing cases seek to clarify legal obligations in terms of other private sector companies, and beyond. We have disclosure requirements in managing emission portfolios, but it also goes beyond that as well to some of the fundamental aspects of their business. And based on the trends that we're seeing, energy intensive sectors such as steel, aluminum, gas production, cement, mining, chemical production are now becoming vulnerable to similar challenges. And future litigation points to a more focused assessment on personal responsibility. And I'm going to bucket this in accountability to shareholders for duty of care, substantiation of claims with science. And I'm just going to pause there for a moment because science and accounting are at the heart of substantiation of climate related claims. You know, we like to say in my world that the best science wins in environmental cases. And science in this instance also is dependent and contingent on sound carbon validatable, auditable, however you want to slice it. That is at the heart of the substantiation, and a key lesson to take away from this presentation is that how do we protect ourselves against risk of climate litigation? Best accounting, best available science. There has been a very strong backlash as well against the use of carbon offsets, carbon credits to enable companies to meet their net zero claims. We're seeing that particularly in the environmental community are pushing companies right now to directly reduce emissions as opposed to rely on offsets from carbon projects such as forest carbon projects or other nature-based solutions, or what we're seeing, direct air capture, to use those that they purchase in the market rather than taking action at the source. And then finally, this whole trend on environmental social governance policy and emission reduction goals has created an opportunity for these stakeholders, shareholders, the public, others that we mentioned before, to hold companies accountable for these climate and other environmental claims. Next slide, please. So what are we seeing here as far as trends? And I thought that these were from London School of Economics, some really interesting data that we've compiled here on climate trends. You can see that it really peaked about 2 years ago in the number of cases being filed. The U.S. still is the dominant jurisdiction for the bringing of cases, but you can also notice a downward tick here in 2023, and a significant downward tick in the number of cases being brought globally. And in particular, we've seen a very significant reduction in number of cases being brought in the United States. That may be due to several things. One thing that certainly comes to mind now is the aggressive climate action plan that the Biden administration has put in place. The activities in the state of California are 2 new regional greenhouse gas carbon trading markets, California Cap and Trade and RGGI. And now we've seen other states join those. So maybe less targets, more organic action and government-driven action may be negating some of that. But as I mentioned, despite the number of cases being reduced, we are seeing new legal theories being tested. Finally, we have this next chart to your right here shows the different sectors being targeted right now, with certainly fossil exploration being the number one target. But you see, little bits from construction materials, retail, transport, utilities, others starting to have some serious contribution here. And if you note on the most recent data, which is 2022, things like travel, personal, and leisure has really been bumped up. And this goes to claims that are being made by airlines for their sustainability. A lot of that is at the heart of that as well. There's also a number of cases, some very interesting cases that are being brought by governments asking for advisory opinions from international courts and tribunals, particularly the International Tribunal on the Law of the Sea, the Inter-American Court of Human Rights, and the International Court of Justice. And while these cases and these type of cases are non-binding, they have really tremendous potential to shape the future development of climate change law, as well as impact some of the international climate negotiations. Next slide, please. A few more numbers to run by you. You'll see here that, look, top left of the slide, many of these cases are being met with success right now. And success from the perspective of this graph is being defined as having a favorable outcome for climate action. There's a trend down below. You can see how this has changed over time, but the percentages have remained pretty stable in that. But notice to your right here, the trend and the proliferation of these greenwashing cases. The LSE calls it climate washing cases, but it's evident here that this is certainly a growing trend that we all need to be aware of. So I'm going to pause there for a second and move on to the next slide. So for the remainder of the time during this presentation, I'm going to go through some climate litigation trends that we've been identifying. These are the buckets that, for the purposes of this presentation, we're going to focus on: deception campaigns and greenwashing, accountability for products and operations, inaccurate, inadequate, and untimely disclosures, insufficient due diligence on carbon projects, and finally, government enforcement of regulations. And so next slide, please. Deception campaigns, greenwashing. Maybe we should start with a definition. And this is more of a generic definition, but of greenwashing. But greenwashing refers to the act or practice of making a product, policy, activity, or organization appear more environmentally or climate friendly, or less environmentally or climate damaging than it truly is. Essentially, it's a form of deceptive marketing or advertising, using of green PR and to persuade the public that certain products or practices are aligned with their environmental values. The complaints that are being filed allege deceptive or misleading green marketing or omissions of a material fact contrary to these green claims. That these products are not, in fact, environmentally or climate friendly. They're not climate neutral or sustainable. So that's at the heart of the allegations being filed in there, that claims are being made, but these claims are not substantiated. Many of these cases are pending right now in the U.S. It's not clear yet how they are going to be resolved. We are still right now trying to understand how these rules are going to be applied. The climate disclosure rules, which we'll come to later, in the U.S. are currently what's known as stayed or on hold, being challenged while the SEC seeks to clarify the rules that they put out for climate disclosure. We are seeing that international and European courts appear more willing, though, to take really active steps against defendants to prohibit misleading advertising, misleading the public to believe that their products and operations have less global warming impacts than they actually do. What types of injuries? Well, the public is relying on this information to purchase the products, but not realizing the impacts on the climate. They are being deceived. Also, that this is a way that companies have also, in some instances, have been making claims about the types of energy and other sources of inputs to their product development process that are happening. Next slide, please. So there's a bunch of case examples, and I think I'm happy to share this presentation with everybody after. And in the interest of time today, I'm not going to go through each of these cases that I've listed out in each of the trends, but it's really for a reference point. But I will highlight just one of these, which is a good example. I'm going to focus on the one here in the middle, the Australian Parents for Climate Action Against Energy Australia. This company was marketing, quote, go neutral products, which the court decided amounted to a misleading or deceptive conduct because its carbon offset initiatives didn't truly cancel out or neutralize the climate impacts of the products that they were calling go neutral. And the court found that the consumption of these products really didn't have a positive impact on the environment. The other case against Shell also is really instructive. This is from the Advertising Commission in the UK, stated that Shell was really misleading the public to believe that a significant portion of its business compromised low carbon products, when in fact that was not the predominant products being produced by Shell. Next slide, please. Second trend that we identify is accountability for products and operations. These are the damages that are being produced by climate change. This is activity allegations to hold corporations accountable for contributions of their products or operations to climate change, or their failure to adapt to climate risk. This is where we're seeing activities by shareholders to challenge company for failure to adhere to their fiduciary duty to protect the best interests of the firm, not properly accounting for climate impacts to physical operations. Most common claim here is, the oil and gas industries have known about global warming and its impacts of GHG emissions for years. There's lawsuits right now being filed all over the world against many of the big companies that you're familiar with, Exxon, Chevron, Shell, BP, others, saying that you knew about climate and its impacts going back to the early 80s and then the early 90s, and you engaged in a campaign of deception and to hide behind this knowledge, ridiculing the science and overstate the economic impacts of climate change to prevent government climate action. And so this has really been at the heart of many of the lawsuits. It's been met with mixed results, however, in the courts. Sometimes we've seen that Courts have been unwilling to find a causal effect between a certain company's operations and damages. That trend could be changing in the future. Typical claims in this bucket: failure to adapt facilities or operations to climate change, direct causation to certain climate-related disasters. And this is the one where the big money is going to come into play here. This is the damage from weather events and hurricanes and tornadoes and other things that are being now trying to understand what was the impact of the changing climate and anthropogenic emissions on causing greater storms, more damage. What is that delta beyond what Mother Nature would have brought on her own? Also, corporate activities, failure to set appropriate emission targets or manage climate risks. And then there's a new big growing trend of human rights or rights of nature violations. And this is certainly a trend that we're seeing in the global South. Next slide, please. Most famous case you may be aware of is the one that was brought once again, this time in the Netherlands, against the Royal Dutch Shell Company, mandating the court determined that it mandated Shell to really change its reduction goal to align with the Paris Agreement across its Scope 1, Scope 2, and Scope 3 emissions. And as you may be aware, this case is being appealed, but it has really had incredible impact around the world. Next slide, please. Inadequate, untimely disclosures. This is rather obvious. You have a legal obligation to disclose or report greenhouse gas emissions, and you fail to do that adequately, accurately, or timely. Typical claims: fail to include indirect impacts, other CO2 disclosures, failing to use good accounting standards, failing to file proper reports. We're also seeing that shareholder actions here for inappropriate carbon pricing, compliance issues regarding certified emission reductions, mainly in Europe, and courts have decided most of these failures to disclose matters against the defense. This is an easier case to prove. I have some examples here as well, but in the interest of time, and I know we're running over, I'm going to skip over these and go to trend 4 right now. This is a growing trend, and we're seeing activities, lots of activity right now in the United States, but it's not limited to the United States. When you are using carbon offsets to support your emission reduction goals or targets, in addition to the emission reductions you're making at the facility, do your due diligence, because do not rely solely on third-party information. These projects and claims are being challenged. We're seeing serious action in the United States, particularly in California, on these topics. Big suits brought last year, both against some household names, Delta Airlines and Etsy, for making carbon neutral claims. The claimants said that, you're making carbon neutral claims that are based on bad credits, so that it's having no additional impacts on carbon levels worldwide, and that you failed to do basically your duty of care and due diligence in attaching those credits and offsets to your climate reduction goals. Next slide, please. Finally, the last trend I'm going to just touch on here before concluding is government enforcement of regulations. And this is also fairly obvious what we're talking about. Governments have rules. You fail to comply with the rules, you are often subject to enforcement actions, which can take the form of civil penalties. It can take the form of injunctive relief, requiring you to take certain actions to come into compliance, and in certain instances can lead to criminal liability as well, usually for knowingly or willful violations, fraudulent reporting, things of that nature. And this is also a growing trend as we're seeing governments become more mature in their greenhouse gas regulatory programs. In these cases, the government holds most of the cards, and we're seeing that these cases are being decided against the defendants. If you could skip to the next 2 slides ahead to the final slide, please, Bradley, on takeaways. Just a few observations. Climate litigation and regulatory actions continue to grow and diversify to major emitting sectors beyond oil and gas. There is ever increasing scrutiny on advertising and marketing initiatives to assure fair and accounting depictions of climate impacts in products and operations. As I mentioned, do your diligence on credit offset investments and the marketing of carbon projects, because there's a huge environmental, non-governmental organization community that is laser focused on assuring that a ton is a ton and these projects are delivering the climate reduction that they are claiming. We're seeing this trend on enforcement against GHG reporting and climate disclosures. Back to the carbon credits, many companies are not only challenging companies on the use of carbon credits against claims, they're also challenging the fact that companies aren't taking actions at the facility, at the project level to reduce emissions and relying on the offsets. And they're saying that is not enough. And finally, these could be culminating ultimately, and we're seeing here in the US that there's a squeeze on right now that ultimately businesses could lose their right to operate for failing to meet emission targets. This is most acute right now in the power generating sector and the use of coal-fired power, but I can see this spreading over time into other heavy industrial sectors. So with that, if you could go to the next slide, I'm going to conclude and really just thank you all for the opportunity to present this morning, and I hope I didn't run over too much.
Thank you very much, Kenneth. I hope you could hear the round of applause you got there here in Brussels. I think in the interest
Thanks for the opportunity, Bradley.
You're welcome. I think in the interest of time, although I'm sure we have questions from the floor, we'll go directly to the next presentation and take questions at the end of the session when we have the discussion then. So we'll say goodbye to you temporarily from the screen, Kenneth. We'll get the presentations up here in the room on both sides, please. And actually a nice segue into the next speaker. Kenneth mentioned that it was increasingly the case that we were seeing climate litigation coming from the global south. So I'm very happy to introduce Parul Kumar, who, as I mentioned, is the Deputy Executive Director and the Climate Director of a Berlin-based think tank, Also, in her spare time, following a PhD in law and criminology at the University of Leuven here in Belgium, who will talk to us about the developments in climate litigation taking place in India. So, Prul, thank you for joining us. The floor is yours.
Thanks, Bradley. Thanks for the invitation. So I work with EPICO. Some of you know me, and our work focuses on, we're a think tank, our work focuses on various aspects of climate, energy, and industry policy. I also work on steel decarbonization in this context at the German, European, and international level. And I'm also doing a PhD in climate litigation, so I'm excited to be here and for my two worlds to meet at this open forum. Thanks for having me. So I thought Kevin's presentation was really a very helpful overview of climate litigation generally, and I will be zooming in on a specific kind of climate litigation, which is constitutional law and rights-based climate litigation. My presentation has three parts. I will first talk about what constitutional and rights-based climate litigation is, touching also upon the definition of climate litigation. In my second part, I will go into two very concrete case studies with judgments from India. And lastly, I'm going to do a quick comparison of rights-based litigation in the EU and in India. So, just as a starting point, I think we should talk about why constitutions are important for climate litigation. As we know, the climate crisis has repercussions on various social, economic, and cultural rights. And constitutions are important documents for countries because they embody a set of rights which have to be protected by the state in relation to the citizens. They also provide access to justice. And therefore, I argue that constitutions are important tools for the transformation in the climate litigation landscape, which need to be studied. So just going more specifically into the Indian context, the Indian constitution guarantees certain fundamental rights to its citizens. Article 21 deals with the right to liberty, to life and personal liberty, and over the years the Supreme Court has actually read in a right to environment in this fundamental right. This has usually been in the context of pollution-free air and water, or the conservation of natural resources, environmental protection, but it is by now a well-established right that flows from this Article 21 right. There's also the right to equality, which is enshrined in Article 14 of the Constitution. This also comes into play in a recent climate litigation judgment, which recognizes that vulnerable groups are unequally affected or more severely impacted by the effects of climate change, depending on their social, economic, and geographical position. So this is also a relevant right to consider. Now, I hope it's the diagram on the screen is visible, because I want to go into a very fundamental question here, which is how do we define climate litigation? Now, we've had many discussions on the definition of green steel, and I think the definition of climate litigation is no less contentious. So it might be argued that climate litigation refers to cases where climate change is at the core of the litigation claim. So you see this in the innermost circle, the dark blue circle, and this is actually where a lot of the climate litigation in the global north is situated. But I think that brings us to the question of whether cases where climate change is not at the core of the proceedings, or is rather indirectly addressed, or is sometimes not even addressed, but the impact of the judgment actually has repercussions for climate change mitigation. Would these cases not deserve to be identified as climate litigation? And these are basically cases that you see in the lighter concentric circles on the outer part of this diagram. And it's interesting, especially with reference to the figure that Kenneth raised, which is from the LSE Grantham report from last year, which I think is a fantastic resource, by the way, for anyone looking to know more about the climate litigation trends. So this figure of 135 cases in the global south as opposed to 2,300 cases worldwide is something that I actually challenged in a recent article that I wrote, because we need a broader definition of climate litigation to also include the differing experiences of the global south and the environmental jurisprudence that is really quite established. And you will find that that a lot of the global south litigation around the environment falls in these outer three concentric circles. And there is really more of a movement now from global south scholars for a more broad-based and inclusive definition. So maybe just as a challenge to that, and while we're on definitions. And maybe I'd like to also point out here that there are strategic reasons for many cases in the global south to not address climate change directly. This is often because other concerns take primacy, for example, developmental concerns. The clash is often between development and environmental concerns, as opposed to the framing in the global north, which can be quite different based on the level of industrialization, and because there are strategic reasons as part of legal strategy to rely on established arguments, tried and tested arguments, because they have a higher chance of success. And these are typically based on the right to environment, the one that I highlighted earlier. Now I want to go specifically into two cases from India. The first one is a very recent judgment from April this year. It's called it's the M.K. Ranjit Singh case, and it's a very interesting backdrop, I would say, because unlike many of the cases that Ken has referred to, where climate change was really directly an issue, here it comes in very, very indirectly. So this was actually a case that a conservationist filed for protecting two species of birds which are going extinct. That's the great Indian bustard and the lesser florican. And it was argued that overhead transmission power lines were causing deaths of these birds, and therefore there was a direction passed by the Supreme Court in 2021 where the overhead power lines were directed to be converted to underground lines so as to protect these birds. But this was found to be infeasible in some cases by the ministries, which were the respondents, the Ministry of Environment, Forest and Climate Change, the Ministry of Power, the Ministry of New and Renewable Energy Resources. It's also important to note where this was happening. This is an area of 99,000 square kilometers in a part of India that's particularly abundant in solar energy. So what does the court do? The Supreme Court goes into a lengthy discussion on the importance of solar power to meet India's climate commitments at the international level, and tries to find a way around this direction and establishes a committee to look into this in greater detail. And we can argue about that at a separate discussion, whether that was the right way to go about it. But here it establishes a very concrete right against the adverse impacts of climate change, which is seen as an extension of the right to environment. So this is very, very significant because it's the first time that an Indian court and the Indian Supreme Court has actually come to such a finding, and has really brought climate change really to the fore in litigation. And so it's going to be interesting to see how this develops. This is a quote from the judgment where this right is directly embedded in the constitutional landscape in terms of Article 14 and 21, so the right to equality and the right to life and personal liberty. There have been different reactions to this judgment. It was big news. It made it to the headlines in several papers. So there are some who think that this promotes a notion of climate justice, and there are some who actually are much more skeptical about it. Maybe I'd like to go into some of these aspects. So as I think it's quite clear that this is a very significant ruling, and it is a boost for rights-based climate litigation for greater accountability, both for the state as well as potentially for the industry. Particularly significant is this great emphasis on renewable energy. So I can imagine that it might play out in the future also in terms of heavy industry adequately or not adequately using renewable energy. So this is significant for this future accountability. It remains to be seen how this trend will develop. It's also significant that the court recognizes very, very explicitly India's climate obligations at the international level. This is also unprecedented in such a judgment. But there are obviously elements that are a bit more problematic or less nuanced, and one of them is, of course, favoring renewable energy industry over biodiversity, because the discussion is not very nuanced in the judgment. It's just renewable energy is seen as a silver bullet, but there are actually also gaps in India's environmental impact assessment for big renewable energy projects as well. It doesn't go into this aspect at all. It remains to be seen how exactly this right will be utilized and enforced in future cases. So it's an exciting space to watch. But lastly, this is obviously an example of an activist judiciary. We're quite familiar with that in India. But this is a court ruling, and it cannot be a substitute for legislation. And in India, there's no overarching climate legislation. There's also no sort of ESG regulations the way we know it in Europe. Of course, there is regulation for preventing air and water pollution, but it's a bit outdated and not so comprehensive. So can the court really step in to substitute legislation? That is sort of like a never-ending debate in India. Now I want to go into another judgment, which also came earlier this year. And here actually there was no climate change framing, but it demonstrates exactly how these environmental concerns become a matter of concern for industry. So this concerns a copper smelting plant in the southern Indian city of Tuticorin. There was prolonged litigation over decades, and I'm not going to go into the details because it played out in various courts. But just to summarize, this plant was closed as per a direction of the Madras High Court. This was due to repeated environmental violations in the air, water, river. There were cases of cancer, asphyxiation. The local residents really suffered because of this plant, and recently the Supreme Court affirmed that this plant needs to close down. And here we actually see the contestation between pollution and health on the one hand and India's need to develop on the other hand, because one of the arguments that was brought forward was that this is a very strategic plant and it helps India become self-sufficient as far as its copper needs are concerned. But this was actually rejected by the court, and I will just quickly go into some of the elements of this judgment. So the court relied on the right to clean environment under Article 21, which I've already discussed, but also some other principles like the polluter pays principle, the precautionary principle, the doctrine of public trust, which is a common law doctrine that states that the state actually holds resources in a public trust for its citizens and must exercise caution when the exploitation of these resources is concerned. Also, the international commitments, more in terms of UN declarations, and intergenerational equity. So, what are the implications of this judgment potentially for industry? Obviously, the closure of a plant is a massive setback for a company like Vedanta, with revenue losses, job losses, stranded assets, and obviously reputational damage as well. This plant was extremely unpopular, and this company is extremely unpopular because of all the problems over the past few years. But at the same time, it's important to highlight that the court, while pitting India's need to develop and self-sufficiency on the one hand, still chose to prioritize the protection of human rights and the protection of environmental resources in this particular case. So what does this mean for the steel sector? As I mentioned earlier, this is a bit of a waiting game, but we have a very significant judgment now which will be used now by litigants to hold industry accountable. This could play out also in the very specific context of whether renewable energy is being used, but also more generally for issues of environmental pollution and the protection of human health. And as I mentioned earlier, in the absence of ESG legislation, this is actually very, very significant because this actually offers the route to litigants to hold companies accountable, to go to court, and to seek directions. Now, before I go into actually rights-based litigation in the EU, there's one case I'd like to touch upon on which we don't have enough information, at least in the public domain. But this is one instance of climate litigation against the steel industry in the EU. This is a complaint filed against Tata Steel in the Netherlands. This has been filed by a prominent criminal lawyer who has now been joined by Greenpeace as well as a complainant. There isn't much information information about this, so I can't comment comprehensively on this, but all that I know is that this is a criminal proceeding filed under Article 173 of the Dutch Criminal Code, which imposes criminal liability in the form of imprisonment for any person who intentionally and unlawfully releases a substance into the soil, air, or surface water. So this is something to watch out for. It's, as far as I know, it's not strictly a rights-based litigation because it's more under the criminal code. But as far as rights-based litigation is concerned, I want to touch upon 3 cases in the EU, and this is a genre of cases known as framework litigation, which means that these cases challenge the overall overarching framework of climate protection and argues that it's not adequate to prevent the desired emission reduction. So the first one is the Urgenda Foundation case from the Dutch Supreme Court, which relies on Article 2 and 8 of the European Convention of Human Rights. This is again based on life and personal liberty. The second one is the Luisa Neubauer case in Germany. This relies on this is a very prominent ruling of the German Constitutional Court, which relies on Article 20a of the German Grundgesetz, which is the constitution, which specifically talks about the rights of future generations and imposes a duty on the state to have legislation in place to protect the future generations. This actually led to some pretty prompt action, and the Klimaschutzgesetz, the German federal climate protection statute, was amended after this judgment to make it clearer or to make it more ambitious. The climate neutrality target was brought forward to 2045, so a very significant ruling, especially in terms of its direct impact. And the last one is a very recent case that's been in the news a lot. This came out in April, another judgment of the European Court of Human Rights. In this case, it was elderly ladies from Switzerland. So this is the Klimaseniorinnen case from Switzerland, who these ladies argued that their rights were being impinged because of increasing climate events and the government's failure to adequately protect them in the form of ambitious climate policy and legislation. And this was also held in favor of the petitioners to say that Switzerland had a duty it basically casts a positive obligation for more concrete and ambitious climate action. So these examples illustrate how framework litigation can invoke human rights to seek greater ambition in overarching climate policy. One aspect to consider here is that these countries have quite specific climate legislation. I gave the example of Germany and the Klimaschutzgesetz, and there is a tendency to anchor this litigation and the arguments in this legislation. So this is significant because they rely on an existing legislation and argue that it's not adequate or it's not ambitious enough. And this is important for the contrast with the Indian approach. So I recently published an article where I analyzed the difference in approaches between the EU and India when it comes to rights-based litigation, and I'd like to quickly summarize these here. So in the EU, as I just illustrated, there is an emphasis on framework litigation with a macro economy-wide approach. There's also an emphasis on existing legislation and a need to improve it. Whereas in India, the emphasis has been traditionally and continues to be so on environmental issues. So this is more of a micro approach, a case-by-case approach. So we see, for example, with a very specific cause, the extinction of a bird, or the violations by a specific industrial plant. So I see this more as a micro approach. The EU cases directly address climate change and emissions. So this, I think, is also interesting because something like the Vedanta case with the copper smelting plant was framed in terms of air and water pollution. I think a similar case in the EU might be framed in terms of industrial emissions. So I would say it's different routes, but the objectives are similar. Then thirdly, there is the climate law element. As I mentioned, there are statutes and legislations and directives to rely on in the EU context. In India, there is no overarching climate law. There are, of course, environmental statutes and delegated legislation, and litigants do routinely rely on them, but there is a difference here. So just want to point that out, because there is no, India has a commitment of net neutrality by 2070, but there is no law that explains how this target will be achieved or what the interim milestones are. So this, I think, is a significant difference, and makes the rights-based and court-based route particularly attractive or favorable for litigants. Lastly, what we've seen in the EU rights-based litigation, and including the cases that I mentioned, is that the claims are based on typically on the future impact of climate change. What's going to happen to future generations? What's going to happen to quality of life? And in India, there is a greater experiential proximity to climate change. Many of these aspects are really now part of day-to-day life. And I think the focus is really more on this experiential proximity, also in the litigation claims, also in terms of the impact of air and water pollution. So it's really the here and now, as opposed to the future, and it's not about future emission budget and so on, which is more the approach in the EU. So with that, I stop, and I'd be happy to take any questions later on.
Thank you very much, Parul. We'll stick with the same format, I think, and indeed take the questions at the end of the session. So let me now hand over to Ana Ruiz, joining us from the think tank based here in Brussels, the European Roundtable on Climate Change and Sustainable Transition. Anna, please join us on the stage. Thank you.
Thank you very much. Thank you, World Steel Association, in the person of Kenneth, for the kind invitation. I will jump right into my presentation. After these previous overarching contexts about litigation risks, brilliantly and acutely given and presented by Kenneth and Parul, my presentation will focus on a specific piece of legislation, the proposed Green Claims Directive that you must have heard about it. The directive has the intent to reduce the risks of greenwashing, to tackle greenwashing, a phenomenon that Kenneth already explained, and which I consider to be collateral damage, side effect of the race to sustainability and the race to decarbonization. Particularly, I will focus on the current development, the most recent update of this proposal, and specifically what can we expect for climate-related claims. A brief disclaimer, this will be a more descriptive presentation as I will go through specific legal text and specific legal provisions, but please bear with me. Starting with an overview, it is important to bear in mind that this proposal emerges within a specific legislative context of Union consumer law. Worth mentioning these two directives, 2005 directive on unfair business to consumer commercial practice in the internal market. This directive is already well established and embedded in national and domestic legislation, and has been recently the legal basis for litigation cases in national courts concerning practice of greenwashing. And the other directive, the 2011 directive on consumer rights. Both these directives were recently amended by a directive empowering consumers for the green transition through better protection against unfair practice and through better information. However, these directives do not specify what companies should do to properly substantiate environmental claims. Therefore, the European Commission put it forward this directive on substantiation and communication of explicit environmental claims, the so-called Green Claims Directive. This, very briefly, we will enter into detail further. This directive sets minimum requirements on the substantiation and communication of explicit voluntary environmental claims and environmental labels in business to consumer practice, which are subject to third-party verification to be delivered ex ante, that is, prior to the claim being used in commercial communications. As it is stated very clearly in the explanatory memorandum of the proposal, the key objectives of the directive are to increase the level of environmental protection and to accelerate green transition towards a circular, clean, climate-neutral economy in the EU, to protect consumers and companies from greenwashing, to enable consumers here to play an active role in the green transition by making informed purchasing decisions based on credible environmental claims and labels, to improve legal certainty on environmental claims, to ensure a level playing field in the current internal market, and to boost competitiveness of economic operators, of business that make the efforts to increase, to improve the environmental sustainability of their products and activities. The proposal was tabled last year in March. And as I already mentioned, I will go through the core articles of the proposal. Article 1 foresees the scope of the proposal. Again, it applies to explicit environmental claims made by traders about their products or about themselves, traders, in business to consumer commercial practice. Article 1 also includes a non-exhaustive list of European legislative acts that are explicitly excluded from the scope of the directive, specific legislative regimes that are already in place concerning other environmental energy claims and labeling schemes. But the really core provision, the heart of the proposal, is Article 3, which identifies what the substantiation assessment of the explicit environmental claims should include. Namely, it should demonstrate the significance of environmental impacts, aspects, and performance from a life cycle perspective, rely on widely recognized scientific evidence, demonstrate whether the claim is accurate for the whole product, activity, or only part of it, demonstrate that the claim is not equivalent to legal requirements, provide information on whether the product performs environmentally significantly better than what is the common practice, identify whether a positive achievement leads to a significant worsening of impact, include accurate primary and secondary information, and concerning specifically climate-related claims, separate any greenhouse gas emissions offsets from the other greenhouse gas emissions as an additional information, and specify if these relate to reductions or removals and how they are of high integrity and accounted for correctly. The other core provisions of the proposal really, as the title of the directive induces, refer to the communication of the explicit environmental claim, Article 5, and Article 10, verification and certification. Really, Article 5 mirror a bit of the article of the substantiation of the claim. When communicated, all environmental claims shall at least cover environmental impacts, aspects, or performance that are assessed in accordance with the substantiation requirements and are identified as significant for the respective product or trader, and shall be accompanied by the information of the substantiation. In addition, for climate-related claims that rely on greenhouse gas offsets, the communication shall include, again, the information to which extent they rely on offsets and whether these relate to emission reductions and removals. Article 10 foresees the establishment of a verifier that should comply with the requirements of Article 11, and it is an officially accredited body by the member states that will carry out the ex-ante verification of the claims submitted by the company wishing to use it. And if these claims are substantiated in accordance with the directive, these verifiers issue a certificate of conformity, which will be recognized across member states, across the EU, and the claims can be made across the internal market. More recently, 1 year later, the European Parliament adopted several amendments. It's impossible to go into detail through all of them, but specifically worth mentioning for the purpose of substantiation of climate-related claims, the amendment foresee a distinction between a compensation claim and a contribution claim, although the amendments do not provide any clear definition of these two types of claim in the Article 2, which foresees the definitions of the directive. Secondly, it also adds a constraint of making compensation claims based on use of carbon credits only admissible in respect to residual emissions, and additionally foresees that the Commission shall adopt a delegated act to establish the method for defining residual emissions. It also foresees that the carbon credits used must be certified unit issue under the certification framework of carbon removals. And finally, regarding, there's other provisions, but for the sake of time. Finally, regarding contribution claims, the substantiation assessment shall ensure that no financial contribution is used to claim an improved climate or environment impact of a product or an activity. It should be an additional information. This past month, April and May, it came to light a compromise text prepared by the presidency. An original version really followed the path of the amendments proposed by the Parliament. It was an original version that was a bit more restrictive to when it comes to climate-related claims, but after that, the presidency reviewed the text at least 3 or 4 times, and these last revisions seem to entail an evolution, a positive evolution on the text. Clarified the definitions of contribution claim and offset claim. Contribution claim here really is a type of financial contribution where the trader claims to have contributed to climate action by purchasing carbon credits, but without using those carbon credits for balancing out a share of its emissions. Offset claims, on the other hand, it happens when a trader claims to have balanced out a share of its emissions by purchasing carbon credits. Again, here the core provisions. The wording changes a bit in the scope, but there's no substantial consequences. It's clarified now. Mentions that the claims are made voluntarily, which is this is important to underline that this is applied to voluntary environmental claims. Regarding the substantiation of explicit environmental claims, it adds a provision specifically for climate-related claims. And again, it states the statement shall take into account the specific nature and aspects of that claim to ensure that consumers are well informed about the use of the carbon credits and their effects. And in the case of offset claims, that is claiming that a trader has a neutral, reduced or positive impact on the environment in terms of greenhouse gas emissions, the assessment shall as well demonstrate that a trader has set a net zero target as set out in the European Sustainability Reporting Standards, and that it disclosed the percentage of total greenhouse gas emissions balanced out using carbon credits for a specific time period. The communication, the wording also is improved and is clarified. I won't enter into detail, and the article of the verification is also clear, as the proposal initially for the proposal of the Commission initially, the title referred to the verification of the substantiation and communication, but now it's clear that this verification only applies to the substantiation assessment of the explicit environmental claim. Very recent developments. Last Thursday, the co-repair seemed to have found a consensus on the text, which seems to be very similar to this last revision that was made public. It foresees a simplified procedure for four categories of claims. First, claims about exceeding a minimum legal requirements. Secondly, claims based on environmental labels. Thirdly, claims about interventions under the Common Agricultural Policy. And fourth, certain types of explicit environmental claims that are defined in the implementing act to be adopted by the Commission. It also cleared and separates some numbers of certain provisions and regarding explicit environmental claims and environmental labels, and the clarification of the responsible parties here, traders for the environmental claims and environmental labels for labeling scheme owners. As I already mentioned, amends the provision on the verification, making sure that this is only applicable to the substantiation part. Set up a specific substantiation requirements for climate-related claims, as I already mentioned, and it introduces a postponed application date of 36 months, that is 3 years, after the entry into force, to allow enterprises, competent authorities, member states, and verifiers to prepare for the application of this directive. The 17th of June, we'll have a first position from the Council of the European Union. Some takeaways to wrap up. My time is running. As we still do not have a provisional agreement between the co-legislators, there's some takeaways that we should bear in mind. There are clear difference between these, the text between the Commission proposal and the versions of the co-legislators, but some may argue that they all go into the direction of additional. And I'm here speaking about specifically climate-related claims of additional legislation and regulation and the tendency of overprotection and over-regulation. The whole effort to legislate green claims, and again here specifically climate-related claims, can be seen beneficial from the point of view of those who provide the credits and those that may want to use them. But also one needs to ask if legislation is necessary and whether it leads to a reduction of individual responsibility and innovation spirit in society. It's very important, it must be reminded that the original intent of the Green Claims Directive was not to regulate voluntary carbon markets, but rather to tackle misleading information, to tackle, to reduce the risks of greenwashing by ensuring transparency, credibility, accuracy of the claims through third-party verification. Therefore, indeed, restricting claims solely to residual emission as the concept, to a certain extent, it is subjective and varies between sectors. It may introduce an arbitrary requirement that will limit the uptake of solutions and removals. Indeed, between claiming that a commercial business, a trader, is carbon neutral, relying solely on the use of carbon credits, on the purchasement of carbon credits, and use them for residual emission only, there is a spectrum of possibilities that could play a role in the company's decarbonization strategy, and including in the steel sector. ERCST then questioned that a more restrictive approach might therefore have an initial chilling effect. We now hear the concept of green hushing. We raised the question that instead of ensuring mitigation hierarchy, it might paralyze companies and sectors in the efforts to mitigate. And if it is the case, it ends up being counterproductive and contrary to the objectives, the key objectives that I initially identified of the directive and the European climate law and ultimately the Paris Agreement. Very broadly, and potential implications for the steel industry. A certain degree of standardization and harmonization, as was already mentioned, on the substantiation assessment and communication and verification of the claims should benefit the green steel labeling, as it may bring clarity and legal certainty. These would ensure, on one hand, for the side of steel producers, that the competitive environment remains fair and the steel producers play the same rules, exactly the same rules, at least in the EU. And on the other hand, for the side of the buyers, when procuring green steel products, the buyer is aware of the rationale behind the claims. And c'est ça. Merci.
Thank you very much, Anna. Please come and join me and Parul here on the stage. And can we also get Kenneth back up on one of the screens here in the room in Brussels? I'm sure we can, and while you're working on that, hi Kenneth, you're back with us now. That's great. So thank you to all three of you for the presentations there. A nice flow, I thought, from the basics and the general overview of the concept down into increasingly specific jurisdictions and indeed legislation in the case of the EU here and the Green Claims Directive. I suppose we do have some questions from the floor. Just to kick things off, I wanted to ask a general question of my own, which I suppose I would phrase as follows. And it touches on something that I think Claire mentioned in her panel that just came up before ours, which is that as the steel industry gets more transparent in its reporting, broadens the scope on which it reports, to a great extent, the numbers start looking worse. Is that an irony, you think, that makes the industry more vulnerable to these kind of claims, this kind of litigation? Perhaps, Kenneth, I could ask that question. I could direct that question to you initially for the broad overview.
Could you just repeat that for me, Brad?
Sure.
It got broken up.
So as the steel industry's transparency increases, as the scope on the things on which we report, our Scope 3 emissions, including methane, our Scope emissions from coal mining, for instance, makes our CO2 footprint look worse. Do you sense that there's a vulnerability coming from the steel industry and that there's an irony in that? Over to you.
Certainly a vulnerability, Bradley, for to try to switch away from carbon intensity fossil. However, the vulnerabilities can be protected by going back to the basics that I mentioned before. Good accounting procedures, best available science, taking steps to reduce emissions at the source to the maximum extent practicable, and actually sticking to a plan. So, and being transparent about how these activities are being undertaken by the firm. So while certainly the vulnerability is there and steel being in the crosshairs as a very carbon intensive industry, progress can be made to reduce the vulnerabilities to litigation through proper plans, scenario analysis, good accounting, and really best available science, and continuing to innovate across the value chain of the entire process.
Okay, thanks. Any other comments?
Okay. Yeah, I think that's a really interesting point because we spoke quite a bit in the previous sessions about information and data and measurement. And I do believe that when we have more of these, this would provide significant ammo to litigants. And if you typically see the legal pleadings where litigants go to court against states or even industry, it's typically a combination or a bundling of many kinds of arguments. So there would, of course, be arguments about the violation of rights or due diligence having not been followed, but this data would help substantiate those claims and provide a sort of a stronger basis. But at the same time, it could be argued that if the steel industry is actually on course to mitigating the emissions as claimed or in an adequately ambitious manner, it would also have good grounds for rebuttal based on that very data.
I think, we will definitely have this transition period that could indeed, as I mentioned, reflect and have this chilling effect on companies, on sectors. But again, it's a step that it's need to be taken, and I guess there's this transition period that will clarify maybe things and will make the sectors, companies and consumers more confident on what it's on the table.
The term green hushing was the word you used, which is a concept I had not come across before. I had a look through your presentation before. It nicely encapsulates.
I heard about it yesterday, actually. Yeah, from someone from the US, and she was telling me that now companies is like, oh, we have this decarbonization target, but we cannot talk about it.
Interesting. I know we've encroached into lunchtime slightly, but if we have any questions from the floor, we can deal with at least a couple before we break then. I see, Felipe, we have one online. Thanks for sharing.
Yes, thank you. The question comes from Jeff Becker from US Steel. So I think it relates, even to a point that was mentioned during Kenneth's presentation. So I think for the steel companies, we have quite a lot of brands that are utilizing green steel claims, or there's also the mass balance approach was discussed in previous panels. So how does the panel think about this in terms of legal litigation point of view of these brands?
Anyone want to take that? Kenneth, perhaps?
I can give it a shot as starters. Jeffrey, I appreciate the question. And I do think the use of a mass balancing approach does create some vulnerabilities, because basically you're assigning your carbon intensive emissions to a subset of products, and it may be perceived as deceptive for your operations totally. So if you're concentrating all emissions on certain products as being a dirty bucket, and then you're going to have very clean green steel in another bucket, this is why it's so critical to have clear rules for accounting on carbon right now. And this is sort of a mess globally. There's lots of different standards, initiatives trying to come up with proper accounting procedures. And until those ways of accounting for emissions and assigning them to products and outputs are clarified, there does remain significant vulnerability to claims that you are greenwashing or sort of playing a shell game with your emissions by moving emissions to this bucket of products while keeping them away from the other bucket and being able to sell at a premium. So I do see trends moving to clarify rules, but until there's really global standardization and acceptance on these principles, I do believe there's some litigation risks and vulnerabilities out there.
Okay, thanks, Kenneth. Anything else from the floor? Yes, here, thank you.
Thanks so much. I have questions for the international law and the climate litigation. As we know, in this May, the International Court of UN Clause, United Nations Law of Sea, and United Nations International Justice Court will provide the advisory opinion on carbon emissions, that particularly for UN clause, United Nations Law of Sea, think the carbon emissions is pollutant, and every country, every business should do whatever to control or mitigate the climate change. So we can find the very big change for United Nations law system. This will influence what kind of influence for the change of United Nations UN clause on the UN International Justice Court will influence the climate litigation. Thank you.
Okay, thanks. Parul, I think you have a comment there.
Yeah, thanks for that question. Indeed, it's a really dynamic time right now. So a few days ago, we had the opinion from the UNCLOS, the United Nations Convention on the Law of the Sea. And I think these are very powerful opinions. We're also awaiting one from the ICJ in the Vanuatu case, and also the Inter-American Court of Human Rights. These will have tremendous persuasive value for litigation also in national jurisdiction. So it would be possible to cite these and say that there is recognition that climate action needs to be, in very specific contexts, more ambitious. So I do see it playing a significant role in future litigation. It was really a big moment when the UNCLOS judgment came out a few days ago, and it was really sort of hailed by many who want to take action in court.
I think I could be forgiven for accepting just one more question from the floor, if there is one. Perhaps not. So in that case, Parul and Anna, we remain around at lunchtime for any questions that pop up later, perhaps. Let me thank everyone, including Kenneth, joining us from Washington, for the interesting presentations. They'll already be available on the website. And let us know if any questions do come up later. So thank you very much, everyone. I'll let you go to lunch.
I'll tell you what they are, right?